Welcome everybody to the Banco Court. Welcome too to people joining us by video from Mackay, Townsville and Rockhampton. I'm a poor substitute today. Justice Martin is laid low by flu. But it's a particular pleasure for me to chair this lecture in the Selden series, to be delivered by my friend and colleague, Justice Atkinson. I won't spend very much time talking about her honours accomplishments, which you can see on the program. You know that she's a former president of the Anti-Discrimination Tribunal and chair of the Queensland Law Reform Commission, as well as having a distinguished career as a judge. She's written judgments like Tyler and Custom Credit, which is one of the most cited decisions in the Queensland legal lexicon, and she's presided over difficult and high-profile criminal trials like the Cowan trial. And as of today, she is the longest-serving judge on the Supreme Court. But perhaps the most significant aspect of her honours career for these purposes is the year she spent as associate to former Chief Justice Brennan of the High Court, which gives her an insight into the environment in which Justice Mary Gaudron spent the most important years of her career. It strikes me that there's no better person to talk about a distinguished, strong-minded, pioneering judge than a distinguished, strong-minded, pioneering judge. So I welcome Justice Atkinson to speak to us tonight.
Thank you, Chief Justice, for your kind introduction. Judicial colleagues, members of the profession, friends one and all, thank you for inviting me to give a Selden Society lecture. I must admit, it's always one of the highlights in my calendar to come to one of these lectures, so I just hope I can live up to those that I've enjoyed in the past. I would like to start by acknowledging the traditional custodians of the land on which we meet this evening and pay my respects to their elders past, present and emerging. I expect we are part of a long tradition of people who've met together to discuss and revere respected elders, as we do tonight. As the title indicates, I'll speak tonight about Mary Gaudron, the girl from the small country town of Moree who grew up to become the first woman to serve on the High Court of Australia. In drawing together the narrative of Mary Gaudron's life to date, certain connections between her early experiences and later motivations and actions appear irresistible. I've been aided considerably in making these connections by the comprehensively researched, albeit unauthorised, biography of Mary Gaudron by Pamela Burton, published in 2010. Justice Gaudron herself said she had a horror of biographies. Consequently, apart from a small amount of material, including my own personal knowledge of her, there is a paucity of personal material available other than what Pamela Burton has assembled in what is a major work of record and scholarship. I encourage those of you who'd like to know more details of Mary Gaudron's life and career to read Burton's book, and I acknowledge the significant extent to which I have relied on it. I should mention at the beginning the personal debt I owe Mary Gaudron. I was just at the commencement of my legal career when she reached the apotheosis of hers. My last day as Associate to Justice Brennan at the High Court was her first day as a judge of that court. She was a breath of fresh air, open, generous and informal. She made her associates a cup of tea. Her family consisted of her two daughters, her husband, there had never been one of those before, and her 5-year-old son, who spent the hour of his mother's swearing in by colouring in, a standby for mothers everywhere, but not usually seen in the High Court. In those days, children under 7, even those accompanied by a parent, were not usually allowed to be in the public gallery of the court, as I found out when Justice Brennan invited my husband to bring our young children to observe their mother in court. I was surprised when they didn't turn up. That's because they were delayed outside. So let me talk about Mary's beginning. Her story commences on the 5th of January 1943, when baby Mary was born at East Moree's railway community. Her father worked as a fettler with New South Wales Railways, placing him, like the other railway workers and their families, in a socio-economic class falling somewhere between the town's wealthy pastoralists and its poor Aboriginal communities. The disparity between these groups was formative in highlighting issues of social and racial inequality that became marked in Gaudron's thinking and advocacy throughout her life. A large Aboriginal settlement called Top Camp was located close to her childhood home, and the conditions there were bleak. Nolene Briggs-Smith, known as Auntie Nolene, an Aboriginal researcher who grew up in that settlement, recalls that living in the tin huts made out of metal from kerosene cans meant living with the smell of kerosene, with the smell of cow dung, and trying to sleep with the noise of the trains shunting at night. More significant than these adverse living conditions, however, was the overt racism directed towards the Aboriginal community in the Maureen Township. In a speech given subsequent to her retirement from the High Court, Gaudron gave the following examples. Aborigines were not allowed on the bus that travelled from east to West Moree, nor in the municipal swimming pool. They were allowed into the picture theatre, but only in the front rows, which were roped off from the rest of the audience. Aboriginal children did not go to school like the rest of us, although some few received rudimentary schooling on the mission. And if they were ill, Aboriginal people were treated, if at all, in the isolation ward of the local hospital. The starkness of this discrimination had a significant effect on Mary Gaudron. She continued, "It was impossible, absolutely impossible, not to be aware that, in the phrase made famous by George Orwell, some people were more equal than others, indeed, significantly so." Indeed, the notoriety of Moree's racial inequality led to it being chosen as the destination for the Freedom bus ride led by Charles Perkins in 1965, the year that Mary Gaudron graduated from university. So her upbringing in Moree gave her an early awareness of the impact of politics on social issues like racial discrimination, in addition to the industrial issues that affected its workers. These were frequent topics of discussion in the Gaudron household, and her father in particular would forcefully express his views on why the then coalition government was ruining the country and why there was a need for Labor Party rule. It is perhaps unsurprising then that an interest in labour law and in anti-discrimination would form an important part of Gaudron's work throughout her career in the law. The prospect of a legal career was itself of early origin. Famously, at the age of 8, Mary received a copy of the Australian Constitution from then leader of the Labor Party and former Justice of the High Court of Australia, Herbert Doc Evatt. Evatt had been giving a speech from the back of a Holden ute, campaigning against the Menzies government's plan to amend the Constitution so as to outlaw the Communist Party of Australia. Mary's intellectual curiosity, even at this age, led her to ask, "Please, sir, what's a constitution?" After determining that it was a bit like the 10 Commandments of government, Mary asked where she could get a copy. The opposition leader told her she could write to him at Canberra and he would send her one. He did, she did, and he did. Young Mary was excited by the prospect of receiving her own constitution, telling her schoolmates about having sent for it. All were expecting some grand or elaborate document, perhaps even some tablets of stone, but were ultimately disappointed to find the copy Mary received looked to be a little more than a small pamphlet. A school bully was derisive. It was just a book and of no use to anyone. "You're not a lawyer," he said. The perhaps inevitable retaliation from Mary Gaudron was, "Well, I'm going to be one." Mary Gaudron was remembered by her teachers as brilliant, quick-witted, and high-spirited. She was not a conformist, producing an essay at her Catholic school setting out why she had concluded that God did not exist. In Mary's last year of high school, she tested the waters of a future legal career by seeking out the advice of a local solicitor. His blunt assessment was that she had set her sights too high and that girls don't do law. This was perhaps her first personal exposure to the issue of gender inequality, something that would become increasingly obvious as she proceeded to ignore the solicitor's advice and set her sights on the path to study arts and law at the University of Sydney, aided by the award of a Commonwealth Scholarship. Mary Gaudron's first impressions of university are evocatively captured in the address she gave on the occasion of her being conferred an honorary doctorate of laws by her alma mater. Those impressions were not of the magnificent sandstone buildings that then predominated, nor of the remote and intimidating academics in their austere black robes, but of the sophistication of my fellow students. They had all the answers. They knew, for example, what was and was not examinable, what to read and what could safely be ignored, whose ideas were in and whose were not. All of this imparted to me and a clutch of other awestruck freshettes from the bush with solemn superiority. Respect for their superiority was quickly overcome as Mary Gaudron settled into university life. She came to appreciate that it was often the question, rather than the answer, that was all important. She worked and studied part-time, took up social and recreational activities, and made new friends, often with those whose unrestrained behaviour encouraged her own. The obstacles put up by entrenched sexism, however, were not so easily overcome. Lectures commenced with the salutation, "Gentlemen," and only that. And many distinguished lawyers took a lot of trouble and effort to explain to her that it was not their policy to take women as articled clerks. Upon taking work at the Commonwealth Crown Solicitor's Office, she discovered that there was entrenched wage discrimination in favour of men, and that if she were to marry, her employment would automatically terminate, as in fact occurred when she married fellow caving enthusiast Ben Nurse in February 1963. Nonetheless, Mary Gaudron stood out at law school as an unconventional but academically brilliant student. She was well liked for her wit, humour, tenacity, and audacity. The latter qualities were demonstrated when the Vice-Chancellor proposed, against the recommendation of the Dean of the Law School, to award the University Medal in Law to a male student who came second behind her in the results. The Vice-Chancellor's view was that the male student was more likely to benefit from the award than Gaudron, as she, having recently married and had a baby, would be occupied in looking after her family. Rejecting this suggestion, Mary Gaudron reputedly said, "The only difference between us is that I sit to pee." Mary was given the award, making her only the second woman after Elizabeth Evatt to have received that honour. The recognition that Mary Gaudron received for her achievements was hard-won, but important. One academic success in particular had the direct consequence of aiding her transition to the bar upon graduation. When, in her fourth year at university, Gaudron sat her end-of-year succession law exam, she was 9 months pregnant with her first child. The course was conducted by then Professor Frank Hutley, QC, a brilliant man notorious for his rudeness and his sheer pleasure in failing students. Some unfortunates had been required to resit the course 3 or 4 times. Mary Gaudron, stretching to write over her baby in utero, finished the exam early and with aplomb, receiving a grade close to 100% and the Succession Prize for topping the year. Remembering her Succession paper as the finest he had ever marked, Hutley invited her to read with him at Wentworth Chambers when she was admitted to practice as a barrister in 1968. This invitation proved useful. Although Gaudron at first refused to squat in Chambers, thinking wrongly that her academic record would invite offers of a room of her own, Hutley's endorsement helped her to overcome resistance to the idea that a second woman would be allowed into those chambers. The clerk had threatened to resign if this were ever to occur. After repeated rejections at other chambers, she, being reassured by others that it was neither discriminatory nor personal, it was just that she was a woman, Gaudron accepted a standing offer to share a room with Janet Coombs, the only other female barrister at Wentworth Chambers. This was something of a vindication for Coombs, who had previously proposed this arrangement to Gaudron, only to be told, rather brashly, "I'm sure I can do better than that." After 2 years sharing rooms on the 13th floor, having become a permanent member after 6 months, Mary Gaudron had a room to herself. 2 more years passed and she purchased Hutley's Chambers, generously offered to her by him at cost price when he was appointed to the New South Wales Court of Appeal. Gaudron carved out a niche in defamation and negligence work, frequently receiving briefs to act on behalf of unions and the Labor Party. No doubt her working class background and stated political views assisted in this regard. However, she did not restrict her practice, taking briefs in diverse areas, including crime, taxation, probate, and succession. Significant cases during Gaudron's relatively short career at the bar included O'Shaughnessy and Mirror Newspapers Limited, a successful appeal to the High Court in a complex defamation matter about Peter O'Shaughnessy's production of Othello, which had been described by a respected theatre critic as a disaster, and the waste and dishonesty of the production had made the critic very angry indeed. Ms. Gaudron appeared without a leader as a junior barrister of only 2 years' standing and managed to have the decisions not only of the trial judge but of the New South Wales Court of Appeal, consisting of the Chief Justice and Justices Jacobs and Mason, overturned. Another important case was the Pat Mackey case, a successful and high-profile month-long defamation trial brought by the prominent unionist Pat Mackey against Frank Packer's Australian Consolidated Press, and the 1972 Equal Pay case, which represented both a career highlight and a turning point for the young barrister. That Equal Pay case, in fact, represented the first of a series of such cases in which Gaudron and others appeared before the Conciliation and Arbitration Commission to represent the Commonwealth, presenting submissions aligned with the policies of the newly installed Whitlam government. Perhaps fittingly, Gaudron got this gig by impressing the soon-to-be Minister for Labor, Clyde Cameron, with her advocacy in the O'Shaughnessy and the Mackey cases. Before the Commission, Gaudron argued forcefully that working conditions for Australian men and women should be on the basis of equal pay for work of equal value, including in industries consisting largely or exclusively of female employees. In doing so, she drew on the International Labour Organisation's Convention on Equal Remuneration. Her success in arguing the position ultimately led to her appointment to the Commission at the age of only 31. Commissioner Gaudron's time on the Conciliation and Arbitration Commission was richly rewarding. She was able to draw on her expertise in industrial law to distill the essence of complex workplace disputes, and she proved to be a skillful negotiator. In describing the work of the Commission, Justice Gaudron said, "There was endless variety. The industrial situations were invariably hilarious, so long as you maintained sufficient distance therefrom, and one had the opportunity for inspections to quite interesting places. Although, in retrospect, I think I could have gone without my interminable inspections of sewage works. Thanks to those, there is no doubt that I can claim to be the only judge of the High Court with an intimate knowledge of activated sludge." She later commented that her time on the Commission was infinitely more fun than being on the High Court. Perhaps ironically then, it was her performance on the Commission that left a powerful positive impression on Bob Hawke, whose government it was that ultimately appointed her to the highest court in the country. The case Gaudron handled in a manner that so impressed Hawke, who was then president of the ACTU, was the 1978 telecom dispute. She chaired a conference between Telecom and the Australian Telecommunication Employees Association, who were taking retaliatory action against each other following staff cuts and strikes instituted because of Telecom's plan to computerise its exchange system. In a day that has been remembered as Bloody Sunday, Gaudron assembled the parties in a hearing room at 10:30 a.m. and almost immediately adjourned the matter to a conference, which she chaired. With no break, during which food was allowed in or disputants out, a settlement was reached at 10:35 p.m, and the proceedings were finally resolved at 11 p.m, ending a month-long dispute during which citizens attempting to exchange in telephone communications had been experiencing considerable difficulties. Hawke later told his biographer, "We all knew she was an extraordinarily intelligent woman, and her sense of humour was a big help in keeping things together. In conferences of that length, fatigue and frustration cause short tempers, and often the whole thing breaks down. It's a tremendous plus if the mediator can keep the atmosphere light." Despite Mary Gaudron's enjoyment of the Commission's work, her work there ended in less than ideal circumstances. She resigned as a matter of principle in protest over the manner in which the President of the Commission and other Commission members had treated fellow Commissioner and friend, Justice Jim Staples. Staples had been resistant to the Fraser government's approach to industrial relations and that government's changes to the law governing how the Commission was to handle disputes, and he spoke out against those changes. Although Gaudron did not approve of all of Staples' conduct in protesting against the changes, she was most aggrieved that the letter expressing disapproval of his actions that she and other members of the Commission had signed had been used subsequently as justification for depriving Staples of his panel responsibilities. Gaudron thus became only the second arbitration justice to resign on principle and the first to relinquish judicial rank by doing so. At the end of 1979, Mary Gaudron took a part-time position as head of the newly established Legal Services Commission in New South Wales. She also became a visiting fellow at the University of New South Wales Law School. Her next highly significant role came with her appointment to the position of New South Wales Solicitor General in February 1981. Once again, she had Clyde Cameron's support for this appointment. Importantly, she also had the support of Frank Walker, who was then Attorney General in Neville Rand's Labor government and had been at university with her. Mary Gaudron was very pleased to be offered the role. She saw it as the best job to have in the law. Her respect for the position was enormous and her ambitions high. She told the media what she hoped to achieve in the following terms. I should like to see a greater awareness in the community at large of legal rights, responsibilities and remedies available. Perhaps in the long term, I should like to see that the law is not something apart from ordinary life. People should see the law is there, not to stand against them, but for their benefit. The position of Solicitor General involves providing frank, fearless and independent advice to the government on often complex legal and political questions. It also involves representing the state in court, putting the government's case. Conventionally, this is a position for senior counsel, but Mary was not a QC, having only practiced at the bar for 6 years before being elevated to the bench of the Commission. Thus, in a rare example of tradition working in her favour, the Attorney General arranged for Ms Gaudron to take silk just prior to her appointment, making her just the third woman in Australia to attain that status. Around the same time, and just days before commencing her new job, Gaudron married her new partner, John Fogarty, and later gave birth to their son, Patrick. There is a story I heard while I was employed at the High Court, which I hope is not apocryphal. One Friday, a case was very nearly completed. All that was left was Miss Gaudron's reply. The presiding judge decided to adjourn the matter to finish on the next sitting day and the following week. An urgent whispered conversation took place amongst the judges, and the presiding judge announced that, on second thoughts, they would finish the hearing the case that day. Patrick, I was told, was born that weekend. The period during which Gaudron held the role of Solicitor General was politically tumultuous, and the range of matters on which she was called to give advice extensive. The reform agenda of the Rann government included formulating a Bill of Rights, prohibiting non-consensual sex in marriage, at that time it was not an offence, bringing New South Wales anti-discrimination policies into line with the UN Convention on the elimination of all forms of discrimination against women, and the recognition of Indigenous land rights, including the proposal to pay compensation to Aboriginal communities previously dispossessed by government resumption of their reserves. Gaudron QC, as she then was, displayed a high degree of aptitude in analysing the interaction of state and Commonwealth powers in Australia's federal system of government. She appeared in numerous significant High Court cases on constitutional issues such as Miller and TCN Channel 9, concerning Section 92's guarantee of free trade and commerce between the states, and the Tasmanian Dam case, concerning the reach of the Commonwealth's external affairs powers. The skill she displayed in such cases was later relied on in support of her suitability for a High Court appointment. Gaudron also happened to contribute to the significance of that later appointment by her involvement as Solicitor General in the move to abolish appeals from the High Court to the Privy Council, that shift occurring just in time for her arrival to the bench of what then became the final arbiter of disputes in this country. Before all this was to occur, however, one particular problem, or perhaps rather category of problems, came to occupy a significant amount of her time as Solicitor General. They arose from the mounting allegations of crime and corruption amongst police, politicians and the judiciary that were surfacing in New South Wales in the 1980s. This environment led to numerous politically charged decisions having to be made about whether adequate evidence had been obtained to support high-profile prosecutions, and decisions concerning which potential witnesses should be given immunity from prosecution. In the absence of the office of the Director of Public Prosecutions, a position created later, it was the Solicitor General whose job it was to make those calls. The pressure around such decisions came to a head with the advent of the so-called age tapes controversy and the allegations that followed involving her close friend and supporter, High Court Justice Lionel Murphy. The Age newspaper had published extracts from copies of cassette tapes and written material purporting to be transcripts or summaries of intercepted telephone conversations, all suggestive of improper connections between public officials and the New South Wales criminal underworld. Solicitor Morgan Ryan was said to be central to the so-called network of influence the Age tapes had shown. Given Ryan's frequent contact with Justice Murphy, the publication of the Age tapes had a snowball effect that had the ultimate consequence of the judge being prosecuted for interfering with the administration of justice. The details of that saga have been detailed extensively elsewhere, including by me in another speech. Relevant for our purposes, however, is that Gaudron's handling of the legal issues raised by this and other similar controversies in the face of considerable press pressure and cynicism was always considered by those who worked with her to be of the highest standard, succinct, timely, and carried out with the utmost professional integrity. Mary Gaudron's appointment to the High Court, the most significant of the many firsts in her career, was inevitably a source of controversy. Not unexpectedly, charges of tokenism, emotionality, and cronyism were directed at her elevation. She was cognizant of the increased scrutiny attendant upon her position as the first woman justice. She noted in her inaugural speech from the High Court bench that too often we emphasise differences at the expense of common cause. I would wish that the day had arrived when the appointment of a woman to this court was unremarkable. Nonetheless, the appointment of the first woman was indeed remarkable, and it, along with Gaudron's force of personality, presaged a number of changes to High Court practice. One early change was that the title Mr. Justice was immediately abandoned by all of the judges in favour of simply Justice. I remember my own feeling of optimism about the future when I saw the nameplates on their chambers being changed on the announcement of her appointment. Another was that she discontinued the practice of having a tipstaff and a single associate, instead appointing 2 young lawyers to the positions. Now it is the norm for each High Court Justice to have 2 associates to assist them in their onerous work. The most significant changes to the Court's embodiment of notions of equality concerned not its members' verbal formulae, but rather their jurisprudence. In this regard, Justice Gaudron was instrumental, and I propose to briefly sketch a few examples. There was, of course, the famous joint decision of Justices Dean and Gaudron in Mabo against Queensland No. 2. As this audience is aware, the question for the court to decide in Mabo was whether, notwithstanding Crown sovereignty, Australian law could recognise the existence of native title rights to lands that have been occupied for generations by the country's First Peoples. If the answer to that question was yes, the question would then be whether, in the particular case, the Meriam people of the Murray Islands in the Torres Strait had established their native title rights. A 6-1 majority of the High Court found that the Meriam people were entitled, as against the whole world, to possession, occupation, use and enjoyment of the lands of the Murray Islands. And, as is well known, even beyond legal circles, in reaching this conclusion, the Court rejected the notion that Australia was unoccupied terra nullius, prior to colonisation. For Justices Dean and Gaudron, this was more than a case of overturning a factual mistake that had been proceeded upon in ignorance in the past. For them, the true facts concerning Indigenous occupation had been long known but ignored. It was therefore critical, in their view, to tell the unvarnished true history of Indigenous dispossession in the judgment, to ensure that the law, from now on, would proceed on a legitimate basis. One famous passage from their judgment illustrates this approach. The acts and events by which that dispossession in legal theory was carried into practical effect constitute the darkest aspect of the history of this nation. The nation as a whole must remain diminished unless and until there is an acknowledgement of and retreat from those past injustices. By stating the history of Indigenous dispossession and discrimination in stark but accurate language, the judgment sought to ensure that, in that case and in those to follow, the legitimacy of legal propositions concerning that history could be assessed in a clear and true light. Justice Gaudron's notion of what equality means was developed over a series of cases, including Street and the Queensland Bar Association, Castlemaine Tuohys in South Australia, and Leith and the Commonwealth. A helpful device Justice Gaudron used in explaining the concept was to define its opposite, inequality or discrimination. Extracurrially, Justice Gaudron succinctly paraphrased her reasoning in this way: inequality is the different treatment of persons who are equal and the equal treatment of persons who are different. In the case law, this apparently straightforward notion was teased out and applied in a variety of contexts. Its subtleties, as revealed by the interpretation and application of anti-discrimination legislation and Section 117 of the Australian Constitution, were articulated. In Leith, for example, Justice Gaudron emphasised that differential treatment of those who are relevantly different will still amount to unlawful discrimination unless the differential treatment is reasonably capable of being seen as appropriate and adapted to that difference. In Australian Iron and Steel Proprietary Limited and Banovich, one of the leading cases on indirect discrimination, Justices Dean and Gaudron found that a last-on, first-off policy of retrenchment, while prima facie fair and non-discriminatory, was unlawful because it operated to systematically benefit male over female employees due to historical discriminatory recruiting practices that had favoured men. As to her judicial manner, she could be robust when she thought that submissions before her were poorly framed. I remember going to watch her when she heard the first of the interlocutory matters in the Patrick Stevedores case here in Brisbane in 1998. In those matters, she pressed Gavin Griffith QC, who just finished his term as Solicitor General for the Commonwealth and was appearing for the Commonwealth Attorney General, on what was the constitutional question involved, which required the case to be removed to the High Court. She refused to put up with obfuscation. I quote, Her Honour, "Well, I want to know what the constitutional question is for these causes of action." His long-winded answer did not satisfy her. "No, but you will not tell me what the question is." Mr. Griffith, Your Honour, the question is whether one has a matter for the purposes of Section 75 or Section 77 or in combination of operation, Your Honour, merely by reason of the fact that the Commonwealth is joined as one of the parties with some 23 other respondents. That is a proposition that is seriously advanced? Well, Your Honour, that's a question to be determined. it is a proposition that is seriously advanced? As a question to be determined, Dr. Griffith, do you seriously contend that a proceeding alleging a cause of action against the Commonwealth and other co-defendants is not a matter for the purposes of Section 75 or 76 of the Constitution? Another attempt at a long-winded and what she regarded as a non-responsive answer by counsel followed. Her Honour, yes, but I am trying to understand. I mean, if you said to me, if you were to seriously advance, and I might of course find difficulties in containing my mirth, but if you were to seriously advance that a proceeding alleging a cause of action in conspiracy against the Commonwealth and other co-defendants is not capable of being treated as a matter in respect of which jurisdiction could be conferred on the federal court, then I can see a constitutional question. I cannot see it as a genuine one, but I could see one. Any judge trying to deal with a difficult matter with an apparently unhelpful counsel would appreciate her exasperation. Justice Gaudron's notion of equal justice found its way into her judgments in a wide range of cases, both criminal and civil. Her thinking on equality, discrimination, and fairness also informed her approach to dealing with cases concerning the meaning of citizenship. Her advocacy in opposition to practices which unfairly diminished the rights of vulnerable groups of people remained, and even strengthened upon her early retirement from the High Court at the relatively young age of 60. When Mary Gaudron left the High Court, she had the joys of rest and relaxation with friends and family firmly in mind. This she achieved with frequent trips to her second home in the Loire Valley. Her French cottage also became a welcome point of detour for many judicial colleagues on their way to and from international judicial conferences. However, Ms. Gaudron did not remain idle. She first took a 3-year appointment as visiting professor at the University of New South Wales Faculty of Law. Then, just 4 months after retiring from the High Court, she commenced a part-time appointment to the International Labour Organisation's Administrative Tribunal in Geneva, a United Nations initiative established to define and protect the rights of workers. The tribunal hears complaints from serving and former staff members of various United Nations organisations, including the ILO itself. In 2006, she became Vice President of the Tribunal, and in late 2009 became its President. Her term on the Tribunal ended in 2012 when she resigned due to ill health. Ms. Gaudron's tribunal work also led to other interesting assignments. Memorably, in 2003, she was appointed by the ILO to a commission of 3 to examine trade union rights in Belarus. Her experience of visiting Belarus in 2004 and interviewing trade union and government officials reinforced for her the value of Section 75(5) of Australia's Constitution as a means of protecting human rights. Ms. Gaudron had been in the majority in several High Court cases that held that this provision guaranteed the availability of review of decisions infected by jurisdictional error, for example, because of a denial of procedural fairness. She saw that the Belarus Constitution contained many guarantees of basic human rights, far more, in fact, than are found in the Australian Constitution. But the absence of an equivalent of Section 75(5) meant that, in practice, these rights could be trampled on with no recourse to the courts. Ms. Gaudron was to speak often about her experience in Belarus, citing it as an example of how human rights abuses can occur even where, at least on paper, there are protections in place to prevent this. The experience also shaped her view that international law and international human rights bodies and necessary and important mechanisms for safeguarding citizens against abuses by their own governments. There is no doubt that Mary Gaudron has had a powerful and lasting influence on the development of Australian law and those who practice it. At the time of her retirement from the High Court, David Curtin QC, then President of the Australian Bar Association, spoke of her work in the development of, quote, every important area of Australian law: the common law, criminal law, equity, conflicts of law, constitutional and administrative law, native title, free speech, and natural justice. Of course, in the time I had available in this speech, and out of a desire to present a snapshot of the entire span of her career, it's not been possible to touch on all of these contributions. What is apparent from even this brief survey of Mary Gaudron's career is that she was a trailblazer, as the Chief Justice said, in Australian legal history. But she should not be remembered simply as a collection of firsts, or as someone who shattered at least a few glass ceilings. There are at least two reasons for that. First, Mary Gaudron's intellect and humanity produced legal work and advocacy of a standard that can proudly stand alone without a token first woman leg to prop it up. Second, as Ms. Gaudron herself was conscious of observing, there is a problem with the glass ceiling metaphor. She discussed this in the Richard Blackburn speech that she gave in 2003. It implies that rather than women being held back by discriminatory practices or unequal treatment, their continued lack of representation amongst the upper echelons of the legal profession and in the wider workforce is down to some mysterious, indefinable je ne sais quoi, some phenomenon not quite capable of explanation. As some of the starker examples of prejudice in Mary Gaudron's life and career show, commonly the problem is much more concrete than that. Although it is not still quite the case that the appointment of a woman to a position of high office can pass without comment about her gender, it is a testament to Mary Gaudron's abilities and personality, to her steely determination to seldom take a backward step, that we are creeping ever closer to that ideal. Let me close on a personal and local note. Mary Gaudron freely gave me sage advice and met with me when she came to Brisbane to check how my early career at the bar was going. She had, I should cautiously mention, a less than entirely complimentary view of the Queensland Bar, as it then was, and initially encouraged me to commence practice in the allegedly more accepting atmosphere of Sydney. However, we can now celebrate that the first female Chief Justice of the High Court of Australia is a former Queensland barrister, that 8 of my 26 colleagues on the Supreme Court of Queensland are women, including the Chief Justice, and that the members of the Queensland Bar, when they stand in this courtroom for their president's speeches at welcome and retirement ceremonies, look slightly less like the front row of a Brisbane GPS rugby team than they used to. I'm glad I stayed here, but it is in no small part because of Justice Gaudron's pioneering role, outspokenness, indefatigable spirit and legal brilliance that these changes have occurred. Thank you.
Well, like many of the Selden lectures, that's been a fascinating combination of legal history and biographical detail, with, in this case, the extra illumination of personal experience of Justice Gaudron. Now, I'm about to give you a gift of which I think Justice Gaudron would approve. And can we thank Justice Atkinson again?